Continuation of case law in GW Act. Manu Goyal versus Srimati Aditi Goyal. This case involves the guardianship under the Hindu Minority and Adoption Act. The also involves the interpretation of section 25 of the Guardianship and Wards Act. The second one is Anju Sanjay. There are various cases, same thing also. Anju versus Sanjay and MJ Janardhanan versus K.A. Nagayaswamy. Conflicting demands of the parents. Here, how this conflict has to be resolved is the honorable judges of the High Court said that the welfare of the child is important, and the parameters as far as the welfare is concerned, it also includes the upbringing, the environment, the education, medical and other benefits as far as the minor is concerned, and as far as the wishes of the minor has also to be considered in deciding as to who is the lawful guardian. And in one of the cases, of course it is not reported, that is Geeta Hariharan's case. As far as illegitimate children are concerned, the Supreme Court recognized the mother as the natural guardian of the illegitimate children. The object of the act is not mere custody of the mother, but the protection of the ward's health, maintenance and education as far as welfare of the minor is concerned. Here also the Supreme Court reiterated the recognized principles by saying welfare doesn't mean mere custody. It also means other allied things like education, medical benefits and other requirements as far as the minor is concerned. But as far as illegitimate children are concerned, the mother was considered as the natural guardian. Then in one of the Supreme Court cases reported in 2008, bracket 9, SCC 413, that is the case of Abhijit Kundu. Here, the parameters of welfare and principle to be considered by the courts, which while deciding questions involving the custody of the minor children came up for consideration. The Supreme Court in a civil appeal against the Delhi High Court decision, partly allowing the appeal filed by the respondent mother against the family court's decision, granting custody to the father, setting aside the underlying orders whereby the permanent custody of the minor children was granted to the appellant father and provided visitation rights to the mother. And the division bench in Vikram Nath versus Satish Chandra Sharma allowed the appeal and set aside the High Court decision and allowed the custody to remain with the father, subject to visitation rights of the mother. What are the facts of this case? The parties were married in 2002 and two siblings were born. It was decided that the mother they would live together, and the minor children in the that the mother would live together with the minor children in New Delhi when father was posted to Jammu and Kashmir. The relationship of the parties deteriorated significantly for the worst. On 8/8/2015, the directing the mother to leave her matrimonial home, and on the other hand, the mother found the house locked, and thereafter she filed an application under Section 12 of the Domestic Violence Act and subsequently a petition under Section 25 of the Guardian and Wards Act was filed seeking custody of the minor children before the Principal Family Court, Rajasthan, by the father, and the same was transferred to the Delhi. He initially stayed the High Court initially stayed the operation of the interim custody and thereafter granted the custody to the mother. The court referred to Gaurav Nagpal versus Sumedha Nagpal, 2009, bracket 1, SCC 12, wherein it was observed that the court must construe the term welfare in the act in the liberal sense, that is, consideration of the court would not only be extended to moral and ethical welfare but also include the physical well-being of the minor children. It being a classic case of parental alienation syndrome, or what is popularly called PAS. The minors were influenced against the mother. No straitjacket formula can be invoked to this principle as laid down in Vivek Singh versus Ramani Singh, 2017, 3 SC 231. The High Court cannot interfere with a written order passed by the family court granting custody to the father. The sum and substance of this judgment is, though people may have what is called sympathy towards the mother because she has given birth to the children, but the paramount interest is the welfare of the minor. Welfare of the minor doesn't mean mere custody. It also means the ethical well-being of the child, the what is called the upbringing of the child, and also because of the parental alienation syndrome, or what is called PAS. Children should not suffer, and they should not be thrown out on the streets. And because of the couple fighting with each other and the relationship being strained, and also when they consider the qualifications of the father, the court held it in favor of the father by saying that the well-being of the children is with the father and not with the mother. But of course, visitation rights was also given to the mother in the course of the proceedings. So this was the next judgment of the Supreme Court. Then, sir. We will now discuss the leftover sections of the Guardian and Wards Act. Section 39 deals with what is called the court can remove guardian on certain grounds. Here, let us say on 39, the welfare of the children is being neglected. The children are thrown on the streets. Children are not properly maintained. Their education needs have not been met. They have not been properly maintained, and they have not been given the minimum support. Then in that case, court has got enormous powers to remove the guardian and appoint another fit person who is fit to be appointed as the guardian in the place of the guardian duly appointed. Then we go to section 40. The guardian can, sometimes I said, I think we stopped with that last time. Sometimes, let us say, because of our preoccupations, because of our being busy with other avocations, or because of our being involved in other activities, we may not be able to take care of the child. In that case, the father has no other, the appointed guardian has no other alternative than request the court to relieve him of the responsibility and permit him to resign as guardian and to appoint an alternate guardian. Then under section 41, when does the authority of the guardian cease? Naturally, by death. Suppose the guardian dies. Then second one is that court of wards assumes superintendence and ward ceasing to be a minor and female by marriage. One is death of the guardian, naturally. Second one is that court of wards, having found that the property is not being properly maintained, it takes the superintendence of the property as well as the custody of the minor. Third one is when the ward ceases to be a minor, he has attained the age of majority. And fourth is when a female child is married, her husband becomes her guardian for all practical purposes. Then 42 is appointment of alternate guardian. That is, suppose the previous guardian has been removed, has been discharged, or as resignation has been accepted, an alternate guardian, whoever is found fit, will be appointed in the place of the outgoing guardian. Then 43 is the conduct of the guardian will be watched always by the courts, and whether they are conducting themselves properly, or whether they're dealing with the minor properly or not. All these things will be scrutinized by the court effectively. 1 minute, sir. Then 44 deals with penalty for removing a ward from the jurisdiction of the court. Will be punished for 6 months imprisonment, and if suppose, let us say, the guardian removes the ward from the jurisdiction of the court, from the supervision of the court, and then in that case the person who does it will be punished for 6 months imprisonment, and a fine of 1,000 also can be imposed. Then 45 is what is called penalty for contumacy. Contumacy means person who has been released from detention has given an undertaking that he will carry out, that is undertaking fails. Suppose, let us say, he gives an undertaking, a person who has come out from jail gives an undertaking that he will look after the child, manage the child, educate the child, maintain the child, fails to keep up his promise, then he is guilty of what is called contumacy, and then he can be sent to civil prison for disobeying the orders of the court. Then 46 is court can call the collector or any court subordinate for a report in a matter, and a report can be treated as evidence. And suppose the court can also say, direct the collector, authorize the collector, empower the collector to give an account of the welfare of the minor at all times, and based on his report, it can be treated as evidence in any proceeding which comes up before the court. Then please remember, sir, as far as all orders passed by the family court or the district court, they are all appealable to the High Court under section 47. And to file an appeal before the High Court, if it is a family court, it is 90 days. If it's an ordinary court, it is 60 days. Then section 50 deals with what is called as if the guardian is sentenced to imprisonment and the maintenance of the guardian in the jail, whatever food has to be provided to him, how he has to be maintained, it is a discretion of the court out of the state funds, or the person who is appointed alternatively as a guardian, as from the income or the property of the minor, has to pay the cost of maintaining the guardian in the jail. Then as far as section 50 is concerned, High Court has got the power to make rules, and it also says that 51 says the cost of the proceedings is the discretion of the court. Court may grant pass or court may not grant pass. So these are the topics which I think by inadvertence it was not beamed, though it was sent, and that's the reason why I covered it, and I also decorated it with some of the case law on the GNW Act and the landmark judgments of the Supreme Court. But one important thing you must remember is the paramount consideration for appointment of a guardian is the welfare of the minor, the well-being of the minor, ethical and moral values, the physical, the suitability or otherwise of the parents, or let us say parental alienation syndrome has to be avoided because of the scuffle or because of the differences between the couple. The child should not suffer. The child should not be thrown on the dustbin or in the what is called where the child faces poverty and starvation. And the paramount consideration is welfare has to be considered in the broader sense and not in the narrow sense. And one more judgment which I have also referred was multiple cases in Washington as well as in our courts. The Supreme Court categorically held that the paramount welfare of the child is to remain with the father because the child was acclimatized to the conditions in the United States of America, and because of the estrangement between the couple, the child should not suffer, and the child can be better looked after by the father in USA. He has got better qualifications than the mother. The mother cannot arrogate to herself that because she is the mother, she has got the paramount right to keep the child. So all these judgments, and some of the judgments, that is only I've referred to the Supreme Court judgments on the particular aspect. Then, sir, so this is as far as the GNW Act is concerned. Now we discuss, or we go to a new topic called the Hindu Law of Adoption and Maintenance Act. Just excuse me, please. Papers.